new guidance out, and perhaps deal with this point first, and then go back to my own friend's earlier points. The point that I think he was seeking to make was that in the light of the judgment of the High Court in this case, there have been amendments to this new guidance, which was still up for consultation at the time of the hearing in the High Court, to take account of the particular problems that arose, issues that arose from Mr. Miller's case. My learned friend has failed to point the court to anything that clarifies the guidance, the earlier guidance, to take into account his case. And indeed, what seems to have happened is that the College of Policing seem to have been emboldened by the judgment below, because I can take the court while I still have it out to page 274. The only bit of substance that I was able to ascertain that's changed in the guidance, and I may be wrong, and I look forward to seeing the track changed version in due course. But can I take the court to example 3 at the bottom of page 274? Because you see, we're now emboldened by the judgment of the High Court. The College of Policing are now bringing this into the schools. So we've now got this acting on in the school classroom and the school playground. So a child who says something derogatory at school can now have recorded, should have an incident recorded against them as a non-crime hate incident. And really, this is the exact opposite of what my learned friend is contending. It gets worse, not better. That's not constraints or sensible or responsible balancing of the respective rights. It's entrenching the errors that were already apparent from the earlier guidance. And the court might wish to know, I understand, I'm not involved with it, but I understand there are proceedings extant about the extent to which this guidance affects school children. So, a very worrying development indeed, we would suggest. These, of course, were set out under my learned friend's heading, considerable restraints being in the new guidance, is the way that my learned friend put it. We weren't pointed to one restraint whatsoever that's been put into the new guidance as a result of the judgment of the court below. And as we see, actually, it's got more extensive. Wanted to make that point while we still had the new guidance out from the end of my learned friend's submissions. I'll deal as briefly as I can with.
Sorry to interrupt you. So I don't have to stand up at the end. My learned juniors asked me to point out it's 274. The new guidance specifically makes clear that this sort of incident would be a matter for the school management team, not for the police. Under example 3.
We'll read it for ourselves. While you're on your feet, Mr. Coppell.
The police should record the incident, it says.
Yes, please.
Just to say that rather than track changes, well, you can do a track changes document, but I would like you to produce a schedule with identifying the changes, specific changes as well, additions and deletions specifically, as well as a track changes document. That would make things easier, I think.
Yes. Sorry.
I'm being told, in fact, although I said track changes, the differences in the format of the two documents is such that will be very difficult anyway.
Yes.
So we'll present it as comprehensible as we can.
Yes, thank you.
The only other point of any difference that is noteworthy that we're aware of, just bear with me one moment, is we see at page 259, and this is picking up, we pick up here my Lord Justice Adam Cave's point about language being important. you'll see that inserted into the new guidance, it wasn't in the guidance before. Note the terms victim and suspect are used throughout the authorised professional guidance practice. To refer the person reporting to an allegation and the alleged perpetrator. These terms do not mean that a crime has been reported or that an investigation into a crime is to take place. So victim and suspect are now given this official stamp of approval by this guidance, and so when we look at the school children's example, the school child now becomes a suspect. And presumably that school child, if they were using social media, would also be subject to the same language, procedure, and so forth. If we can return to my learned friend's submissions at the outset, he started off by making the surprising submission that paragraph 6.3 of the policy we're challenging is not an instruction to record. Well, as the court will immediately notice, it's exactly what it says it should do. My learned friend says that the instruction to record comes from the national standards for the national standards that you referred to. The curious feature of the scheme then is that there's no reference in the hate crime operational guidance to the national standards. There's no suggestion that there's somehow parasitic upon the other, and one has to read the two together. It doesn't say that. There's no suggestion of that at all. And a theme that ran right through my learned friend's submissions was that due to the operation of both of these sets of guidance, the HCOG, the Hate Crime Operational Guidance, actually made no difference, and that was in essence what was being said repeatedly. Now, my Lady Justice Simler asked my learned friend both before the lunch break and after how an incident such as the one that prompted these proceedings would be recorded under the national standards. And my learned friend was unable to answer. Would it be recorded as a complaint was made, or would it be recorded as a hate crime? We're now told, well, they'll let us know. But we've been right through the High Court proceedings, skeleton arguments, the final afternoon of the second day of the Court of Appeal, and he's still unable to present evidence, which is a central plank of his case, because his case essentially is none of this matters. We then had submissions earlier before the adjournment about the very limited circumstances in which the enhanced criminal record checks might become important in a case such as this. And there's a couple of points to make on that. The judge below posited the example of Mr. Miller applying to work with transgender children as being an obvious example of where there would be disclosure. He wasn't saying those would be the only circumstances where this police record would be disclosed. But my learned friend then bowderises that by saying, well, it's only in these very limited circumstances that the record would be disclosed. That's not what the judge below said at all, and there's no warrant for that submission. What he went on to say, my learned friend, is that it may or may not be disclosed. Well, there we go. That's the uncertainty. But for our purposes, it doesn't matter what the precise circumstances are, whether an incident such as this would be disclosed. The point is the chilling effect of the possibility of disclosure. Not just with respect to an individual incident such as the one that gave rise to these proceedings, but in general terms, the chilling effect that if you go on social media or express yourself in any other way, in a way that might upset someone, you may well be, you stand the very real possibility of having a police record, the police recording something with respect to it. And
one notes from the new guidance, page 274, that example 2 is where an incident takes place at a party at somebody's home.
Yes. Yes. Well, I reiterate the point, my lord, that the College of Policing are obviously emboldened by the judgment of the court below. And the reach just seems to get greater and greater. They're saying that they've got too many of these incidents, too many of these reports to deal with. The figure of 140,000 comes to mind. I think the people behind me are going to try and work out exactly where that figure comes from, but I seem to recall having read that 140,000 incidents have been reported to the police, but I must double check that. I don't
and
know.
over what period?
I'm not sure.
We have to be careful. What we do know is that we're told that the volume is such that investigation is not possible.
I'm sure I've seen some figures somewhere, my lady, but, and we'll do our best to.
Well, we're not inviting you to put in further evidence.
No.
In relation to that, and so please don't unless it's asked for.
No, I'll endeavour. Another curious feature of my learned friends' submissions, if I may say so, with due respect, is that there's been a significant change in the way that the College of Policing have presented their case, both in the court below and in the written submissions to this court. My learned friend never didn't recognise that what happens as a result of paragraph 3 of the hate crime operational guidance is a recording. He used the word categorisation repeatedly, probably 2 times during his submissions, and that's clearly a deliberate decision on the part of the College of Police and its representatives to try to make the whole procedure more palatable. But it isn't a categorisation. It's a recording. That's what it says on the tin. Hate crime operational guidance. You must record. He also goes on to say, well, it's not intended. HCOG isn't intended to be a comprehensive manual, as if somehow that absolves the College of Policing of any responsibility for any admissions. Well, that may well have had some traction in earlier versions of the guidance, but it certainly can't have any tractions in the current version. And Melanie Friend said on a number of occasions, this is high-level guidance. I wasn't quite sure what that was supposed to mean, but what we do know is that the hate crime operational guidance is a manual given to police officers and staff as to how to deal with this kind of situation. That's exactly what the College of Police is tasked to do. And it's that guidance, of course, that the officers on the ground rely on when they're dealing with these complaints. We then move on to deal. That was it with those comments with respect to the preliminary points Melanie Friend made. We then come on to deal with the issues in the case. And the court will recall that Melanie Friend placed great weight on Lord Sumption's judgment in the CAT case about the lawfulness of retaining data. And of course we accept that, and you'll recall that we made a point at the outset of accepting that there is a common law power vested with the police to enable them to collect and retain data. Lord Sumption's obviously right. But that doesn't mean that they've got the power to retain any data whatsoever without any constraints at all. Just think about that for one moment. The police wouldn't have the power, for example, one would imagine they would at any rate, to record information about the political views of individuals, about the sexual orientation of individuals, about intimate details of individuals. No, the common law power, just because there's a common law power providing that the police can retain information, doesn't mean they can retain any information about anything. And plainly, Lord Sumption wasn't saying that he was. Plainly relevant, however, to the Cat case and the kind of factual information that the court was concerned with in that case, which is consistent with the generality of the information that one would anticipate that the police would be gathering and retaining. Turning now to the particular grounds, I don't intend to say anything more about ground 1. As we identified yesterday, it adds nothing to the Article 10 challenge. Some courts prefer to go down a common law route, some courts prefer to go down a convention route. We've developed the arguments more along the lines of the convention route. With respect to ground 2, very surprising that my learned friend completely mischaracterised our case. What he said, it was the rationality of perception-based recording. Well, that wasn't our case at all. Our case, if the court will recall, was the rationality of recording hate incidents regardless of whether there's any evidence of hate. So, not surprisingly, my learned friend didn't address that argument at all. Merely changing the question that has to be answered doesn't absolve any responsibility from answering the question in the first place. So we don't have the benefit of any submissions on that particular submission. But whilst my learned friend was making those submissions, my Lady Justice Simler asked my learned friend the question about a distinction between racist incidents and other incidents, and I apprehend my lady had in mind Kathleen Stock's second witness statement, where she sets out, and I'd invite the court to read this more generally, where she sets out how behaviour and language can operate very differently. As a philosophy professor, one would expect this sort of rigour. Can behave very differently in different contexts. Put very short, I'm not going to take the court to it at the moment, but put very shortly, what she said with respect to racist comments is you can generally identify it pretty clearly if we have racist comments. Whereas, contrast that with transphobic comments, there's a very great difference of opinion, and indeed a large proportion of the population, we don't know what, wouldn't even recognise the transgender debate. Whether a man or, she uses the analogy of post boxes, if I recall correctly, and she says that very many people would think the question of whether a person is a man or a woman is as straightforward as whether letterboxes are red. And that's the way, for right or wrong, that's the way a lot of people would perceive it. So language is much more difficult in this area. I think that's one thing we can all agree on. Whereas the racist language is hateful and abusive racist language is much more immediately apparent, is the gist of what she said. I'd invite the court to carefully look at those. It's a short statement, it's a second statement in the papers. But because, and the point's important because the genesis of this guidance is the Stephen Lawrence inquiry, as we've seen, and some international materials about combating racial abuse and hatred. None of which we seek to in any way undermine. But as we said at the outset, in opening, Sir William Macpherson didn't say that all these, or even racist incidents, shouldn't just be recorded willy-nilly without any investigation. He said they should be investigated in just the same way as racist crimes. So the whole concept has been bowdlerised without the element of fairness that was implicit in what was set out in the what was recommended in the Lawrence inquiry. My learned friend then went on to say, finally, on rationality, the guidance was held by the judge not to exclude normal rationality constraints. So my learned friend developed this concept of rationality constraints, and I can only presume that what he means there is
is the judge below's acceptance of what Mr. Williams said about police officers using their common sense when they're recording these complaints. Well, number one, there's a difference between common sense and rationality, and the point being, when we made absolutely clear in opening, one person's common sense is same as another person's common sense. Now you could say that about rationality, but rationality is a much higher threshold. As lawyers, we commonly think of the red-headed teacher example in Wednesbury, but for something to be irrational is a very high threshold. As a matter of common sense, people would take very different views. So my learned friend would say it's quite wrong to say that there's rationality constraints within the scheme. And the point is that there isn't any rationality constraints in the scheme. We say that the judge below was completely wrong to accept without any further evidence what Mr. Williams said in his statement. And if there was any doubt about that, one just asks the rhetorical question: well, why wasn't that put in form in the new guidance? If that is an important part of the structure of this in the framework, well, it should be there in the structure. Police officers should know, and moreover, the general public should know. But on this ground of challenge, the second ground of challenge, my learned friend doesn't even begin to address the questions that are posited on our part. We then move into the Article 10 territory and deal with interference. And the main point that my learned friend makes, and this straddles the adjournment, he made it just before and just after the adjournment, but there's no case law to support our case on interference. Well, there'll never be a case exactly on all fours. That's the nature of the process, certainly not at the higher courts. But there are analogous cases. We're considering here interference. In CAT, the recording of factual information was held to be an interference with the Article 8 rights. By analogy, one must see the force of that in respect of Article 10 rights. And of course, in the Turkish case, Akram, the court was shown how the European Court dealt with interference there. The learned friend didn't take the court to the Turkish case on interference. But of course, we heavily rely upon it. On interference, one of the submissions my learned friend made was that the guidance is about recognising what would be in any event recorded as a hate incident. I think I've quoted my learned friend correctly there. Again, this is this point about that he makes continually about the recording that would take place under the national standards, without having any evidence or being able to show the court or anybody else what actually would be recorded under the national standards. And just pausing there, then, my Lord Justice Haddon Cave noted that in the national standards we see the same language replicated, that's the offending language in paragraph 6.3 of the operational guidance. It's unclear how that's operated. But the truth is that if the language of paragraph 6.3 is found to be unlawful and offensive, then that would almost certainly be read over into the national standards for information recording. It really doesn't take them anywhere. It's a form over substance point, if there's anything in it in any event. After the adjournment, my learned friend is still on interference. my learned friend, it's difficult to see how categorisation could stigmatise anyone. Again, we underplay the impact of what's going on here by a change in the language, categorisation again, and stigmatise. But of course, the judge made the finding that we saw with respect to the police. That's repeated at paragraph 257 of the judgment. It's paragraph 40 of my client's witness statement about the sense of both personal humiliation, shame for the family, embarrassment for his company, and anxiety and so on, which the judge said would be the reaction of anybody who'd been exercising their free expressive rights and received a visit from the police as a consequence. But of course, as we identified yesterday, that paragraph was said in the context of the record, not the visit from the police. So the first half of paragraph 258 carries just as much weight regardless of the second half. What we see there, paragraph 40 of Mr. Miller's statement, is, as the judge found, the reaction of anybody exercising their free expressive rights. That's a matter of common sense, we would say, to use the respondent's language. So,
although, Mr. I'm so sorry to interrupt you, but if there had been a mere recording without any follow-up by the police, Mr. Miller would never have known about that entry.
Well, he may never have known. He may.
I'm so sorry. What I'm putting to you is that although he's complaining about recording, he's inevitably he must be identifying his response to being told that there was a recording and being talked to by the police.
Absolutely, my lady. What I was drawing the distinction was the knock on the door by PC Gull and the questions, and you've seen the evidence about what was said in the exchanges and so on. That was what the judge below found to be beyond the pale. Frankly, it wasn't just being told that there was the recording. It was the officer's actions.
But my lady's point is that if there had been no knock on the door, he would never have known.
May well not have known.
So how does that leave your argument?
Because he may well become aware that in the world of social controversy, that the police are becoming involved in these cases, just in the same way that Mr. Miller's wider family got to know about this as a result of what happened to him. Then there will inevitably be other families who get to know, and generally the message will get out there amongst people on social media. It's inevitable.
Who read the Miller case and the reports?
No, those on social media, and that doesn't include me, I hasten to add, will be told about what's going on in these sorts of cases. It's inevitably it will be a very abridged version as well, of course. But the very short point is, there will quickly become a general awareness that the police are collating all this information. And that's the point I think my lady made yesterday about the chilling effect amongst the general public. I mean, one could just posit the question, just returning to my Lord's question. We've now got this guidance with respect to children and what have you. One doesn't have to think very, very hard to imagine how quickly round the playground and round the school it would get if questions were asked about the sort of example that's in the guidance, or a multitude of others. But it's no defence to say, well, we're doing it and we won't tell anybody, and we'll collate all this information anyway. That is offensive and contrary to Article 10 itself in any event. But that's not the policy. The policy isn't to do secret. My learned friend then then said there was no wider evidence about the chilling effect. It was picked up with respect to Professor Stock's evidence. There's also, of course, Jodie Ginsberg's evidence, the Chief Executive Officer, as she then was, of Index on Censorship. And she does give some actual examples of police involvement in social media. So that then is interference, and surprisingly, no mention in Maloney Friend's submissions about the case law that refers to the very low standard that's required in the particular place that freedom of expression has in the convention jurisprudence. We then moved to the submissions on prescribed by law, and this was it was surprising, to say the least, that Maloney Friend never used the word foreseeable once in all his submissions on prescribed by law. Again, that was obviously a deliberate choice on the part of the College of Police and their representatives, because foreseeable is of course the language used in the cases. It's the standard test for these purposes. And that then gives rise, and the word's used for good reason, because it gives rise to the question, could a person foresee the consequences? Now the question was the consequences of their actions. The question, the rhetorical question that was put yesterday, was how on earth could somebody like Mr. Miller or anybody else in his position foresee the reactions of somebody like Mrs. B acting on the outer limits of rationality, or whatever the phrase was that Judge below said. And that's simply not addressed by the other side. They simply don't address that question. And they don't do for good reason. There is no answer. There is no logical answer that could be given to as to how anybody could foresee the reaction of an irrational person. It's an oxymoron. It just simply doesn't make sense. Maloney Friend, rather than rely on foreseeability, the correct test, drew on one paragraph in the Bridges case about the principle of relativity. But that's a secondary question. The primary question is the foreseeability question, and as you say, doesn't even begin to address it. And that, of course, is a key question. Possibly, ultimately, the key question. In fact, when you boil, when this case is boiled down. We then move to proportionality and what Maloney Friend had to say about that. Again, he reiterated his points about lack of impact. We reiterate our point in response to paragraph 40 of Mr. Miller's statement, the point we made about interference. And Maloney Friend, surprisingly, in his submissions on proportionality, entirely ignored our submissions about the special protections provided for political and controversial debate. It's paragraph 50b of our skeleton argument, which, as we know, requires a very compelling reasons indeed to curtail. We're not considering here rationality in an academic sense. This debate on social media is the new lifeblood of democracy, and there needs to be extremely compelling reasons to curtail it. Finally, Maloney Friend addressed the court on safeguards. Made the point that if you don't know, there's no need to safeguard. Well, that I'm afraid doesn't take Maloney Friend far, because it ignores the chilling effect of the policy generally. And then we came to the point you made about the new. The fact that the College of Policing have concerns about how Humberside acted, which is a surprising submission given that they full-heartedly supported Humberside's actions in the High Court. And they weren't neutral or lukewarm. They were fully supportive. So considerable were the concerns, my learned friend says, was that they've changed the guidance to deal with problems. But we've seen then my learned friend went on to point the court to a number of provisions in the guidance which just replicate the previous guidance. That doesn't really support the submission that the guidance changed to deal with the problems that this case gave rise to. And as I said at the outset of my submissions, what they've done is to embolden the guidance to make it more expansive rather than less so, which will have a greater impact on freedom of speech generally than it has before. I think I've dealt with all the points that my learned friend made. I don't know if there's any other points I can assist the court with. Oh, my learned junior reminds me the point about not knowing about the case, but of course in this case not only did the operational police take the action that they did, but the assistant chief constable posted a statement in the papers saying that it was correct to make the record in Mr. Miller's case.
After the litigation?
No, at the time, just before the pre-action letters, but it just shows the level of support that was given. So if it was concerned that this is a road case that something's gone wrong, one would expect it to be looked at again and it be identified. Whoa, this is we need to remedy this and put it right. That wasn't the case at all. Right up through the ranks of the police that was supported, and as the actions of Humberside was supported, as it was with the College of Policing. So that indicates that this is what happened in Mr. Miller's case is consistent with the police generally's approach to non-crime, the recording of non-crime hate incidents or the complaints about non-crime hate incidents, and exacerbates the concerns about the uncritical recording of such complaints as being non-crime hate incidents. I don't think I have any other submissions unless you've got any questions, ladies and lord.
Thank you very much. Well, thank you very much. Can I thank counsel on both sides and those behind them for the hard work that's gone into preparing this case for us. It won't surprise you to know we're not going to give judgment immediately. We will consider our judgments, and drafts will be circulated to the parties in the normal way for the correction of any spelling and other obvious factual errors, but obviously not for re-argument. If we do want assistance on any particular point, the parties will be told. The judgment will be handed down. It may be remotely, it may be in person, depending on where we've got to by then, and there will be no need for the parties to attend. We would invite the parties, if they can do so, to endeavour to agree a draft order for the court's approval before the hand down. Again, if there are any matters which need to be dealt with in consequence of the decision that we arrive at, then those can be dealt with in writing. But again, we will invite submissions if we consider we need them. Can I reiterate my thanks to all concerned? So unless there's anything else, we'll rise now. Thank you very much.
I'll rise.
know a song about a miller, don't we, Gabriel?
That's right, and the mice have a roll of music for it too.
The marvelous mechanical mouse organ.
Ploughman, ploughman, plough me a field, turn me an acre of land. Ploughman, ploughman, harrow the ground, drill in the seed and roll it down. For the year will turn and the spring come round, and the seed will grow. Shine the sun and rain the rain, fall the shivery snow. Frost and hail and wind again as the year will go. Farmer, farmer, the field is ripe, tall and straight they stand. Farmer, farmer, it's time to reap, time to combine the corn to keep. The straw will blow and the chaff will leap, and the grain will fall. Shine the sun and rain the rain, fall the shivery snow. Fog and sleet and hail again as the year will go. Miller, miller, take up the grain, pour it out like sand. Miller, miller, open the rill, to turn the wheel and work the mill, to grind the grain to flour and fill the sacks below. Shine the sun and rain the rain, fall the shivery snow. Hail and wind and sleet again as the year will go. Baker, baker, the flour is here, soft and fine and bland. Baker, baker, get out of bed, put that silly old hat on your head. Bake me a loaf of golden bread, and then I'll go. Blow the wind and rain the rain, fall the shivery snow. Soon the sun will shine again as the year will go.
Thank you very much. Thank you.